when a case is coming to court. You don't have to wait until the day before to find out. The calendaring system should be a month out, so you can have that for a month going forward. You already have court watch that's there. That should be there. And that's another way to make sure that it's accessibility and they see everything that's going on. A third thing that we as judges need to let people know when we're going to be in court. If your court bus start at 8:30, be there at 8:30. If your court starts at 9, be there at 9. And if there's a reason why court is canceled because there's some emergency, you need to let the public know, instead of having to try to find out by hook or crook. That's what we need to do right now. That's how you show accessibility so everybody knows what's going on in the court system.
First of all, I think one of the things that's been lost is that, in this parish, other parishes that I've practiced in, judges don't keep regular court hours, or should I say regular office hours. Most of them come to court, they run the docket, and then they're gone. Sometimes they're out the building by 11 a.m., sometimes they're out the building by 12 a.m., and you don't see them again until the next day. One of the things that I would do if I was elected, I would have regular office hours. Regardless of how quickly we finished our docket, I would still be available. That way I can answer questions that I'm allowed to answer. Because a lot of times you have people that come, you have court watch citizens that may have questions about things, and they're usually talking to the minute clerk. We sometimes have reporters like Mr. Cinnamon or Mr. Daly that want to get an update on something they missed because they were covering a trial in another section of the court. So I think that having regular office hours and granting access to the interested parties is one way to do it. Secondly, again, you engage in everything on the record that can be engaged on the record. As I previously stated, you can't put everything on the record all the time, but there's no need to be conducting pleas or, certain type of conferences in chambers. Everything does need to be protected on the record because everything goes up to the circuit offices in court when cases are being reviewed. And when it comes to accountability, I think that falls on you all shoulders. Citizens need, if you're unhappy with your judges, if you're unhappy with the judges that you've been elected, that are represented, then when you go to the polls, you need to take action. Don't just continue to elect the name that you're familiar with. Don't just continue to elect the person because they're an incumbent, because their name appears on every ballot that gets mailed to your house right before election day. If you're unhappy, you have to hold them accountable. The judges that are failing you are not going to hold themselves accountable.
Thank you. I hope my remarks about witness safety or victim safety were not misunderstood. I am the author of the lead case on how a judge is to proceed in protecting a witness's safety in private. Now that's one thing. I do take a little different view, though, of judges participating in plea negotiations and working out deals and so forth. I am of the firm legal opinion, that judges have no business coercing, suggesting, encouraging people to plead guilty. That's what my point is the judge, if the prosecutor and the defense lawyer want to go in a side room and talk about a deal and what the prosecutor is going to give to the defense lawyer, that's their business. The judge should not be in that room. Should not be. She should not be. Now, when they come out and the judge is there and the public is there, then that's when it's all going to be put on the record. If they make a deal, they make a deal. But the judge should not be involved in it. Now, on the issue of accountability and public trust and transparency, I think what would go a long way, a very long way, is if some judges would just cooperate with people who are trying to reform the system and work towards change in the system. So that if you have an organization, and this is not a sycophant statement, this is a belief, like the Court Watch, that has people in the courtroom, we don't need to be oppositional to that. We don't need to be oppositional. We should welcome that. We should welcome people being in the court. If the news media is in the court, we don't need to hide from them and run away. Can't talk to them, or, can't talk to them, but they need, that's why it has to be on the record in public. When that's there, when you're conducting court that way, that is as accountable and transparent, and there's nothing wrong, with the judge taking the time to explain on the record what the judge is doing and what is the process in full. Thank you.
I'm glad you raised the work of the group Court Watch NOLA. They obviously play a role as sort of being eyes and ears for the general public. And that addresses the next question, which is there anything that can be done to support Court Watch NOLA, the media, other organizations that provide that sort of public oversight of the courts?
Well, I think first off, and I very much agree that we should be making the proceedings that take place in a courtroom on a particular day productive. This notion of putting 80 cases a day when you know you're not going to do 80 cases is ridiculous. All right? Now, when you say, if you manage the court and you manage the business of the court, and you say, until, for example, discovery is complete, we're not going any further down the road. Then everybody knows, okay, when this date is set for motions are going to happen. It's not going to be a deal of just loading cases onto a docket pretending that something's going to take place when everybody knows it's not going to take place. So yes, I think, and then the people who have an interest, they know, hey, Judge Bonin said, these are the 3 motions that are going to be heard that morning. These are the 4 sentences that are going to be passed down that afternoon. You want to be there? Be there. It's very simple, but it's avoid the clutter. Avoid the clutter because it's all unproductive, and we all know that. And that's what leads to continuances and postponements and all of that other foolishness. Doesn't need to happen. Thank you.
I've been criticized a lot by telling people that, first of all, I'm a big proponent for televised court proceedings. I can watch a trial in another state when you have to come down to court and hope that you can get let into the courtroom to actually see what's going on. So whenever Louisiana is ready to actually start televising court proceedings, Section B will be the first courtroom you can come set the cameras up in. Now, until then, to actually assist Court Watch NOLA and the other groups as well as the media that are trying to cover cases and have transparency, the first thing you do is treat them cordially. I've seen so many times judges calling out the Court Watch members with the clipboards, wondering what are you doing here, what case are you following, getting off the bench and trying to wait till you leave so that they can actually, go ahead and finish conducting court. They try to stall certain things until you're no longer in the courtroom because they're afraid that you might write a negative story about them. Because they agree to a lenient plea or something of that nature. Again, I think if you're doing the right thing, if you're ensuring that justice and fairness is being served, if you are following the law, I don't think you have anything to be ashamed of, so there's no need for you to hide the activities of the court. There's no need for you to try to stall your decisions until the courtroom is empty. Unless it's in the interest, a safety precaution, such as taking a little bit of evidence from someone so that it doesn't go on the paper. We don't want the newspaper reporting that someone maybe had cut a deal and now cooperated witness, but other than in anything that's not special circumstance, just treat the people respectfully and conduct business in front of them and don't try to hide things. And I think that makes their job a lot easier when it comes to covering the activities of the court.
I'm going to sound like a broken clock here. We need to use technology. It makes no sense why the court should not have free Wi-Fi in the court, by which the people from NOLA Court Watch and any reporters can actually tie in and actually start using that to actually deal with their stories and get that information out. That's the first thing. A lot of things that Mr. Bonin, Judge Bonin, and Mr. Hillary has stated, I agree with the exception that at some point I believe we will get to the point where we will have televised televisions in the courtroom. And I think I'll be ready for when that occurs. But one thing that Judge Cronin did mention is about the dockets. One of the issues that we have is that the DAs are the ones that are controlling the dockets. They are the ones that are putting all these cases on the docket at a time. That clogs the system. And then once they clog the system, then you will have 80 things on the docket, and then you only have 20 things that go forward. That's the first thing. Another thing that was stated in the prior question that you asked, Judge Cronin said he would never be a party of a plea agreement where you have the state and the defense attorneys that are discussing trying to do a plea agreement. A part of the judge is set to do the sentencing. And if I'm the judge, I'm going to be there because I'm not going to allow someone to do a plea deal on let's say, a armed robbery, and then say, you can give the guy 10 years. If it turns out that the person actually did something that should give 50 years, that's the judge's preview in sentencing. So you have to be a part of it. So I'm not going to try to give away all of, say, I'm going to do this, that, and that. The judge is going to rule his court, and I will rule my court.
Okay, one more transparency and accountability question. It's a good one. I've often wondered this for myself. Obviously, there's great accountability in electing our judges, but almost no accountability or transparency in the selection of magistrate commissioners. These are positions that carry a $70,000 a year salary, part-time, in which those commissioners are allowed to maintain a private practice. It's almost like choosing a pope, minus the black and white smoke. We have no idea of the process used to select these commissioners. Would you make any changes in that process to increase some accountability and transparency?
And yes, I would. One thing, when you look at the commissioners, when commissioners are coming up to be appointed, I believe that it should be placed out where everybody knows that it's actually time for a commissioner to be appointed or go through their application process. In dealing with that, you need to look at commissioners who actually have practiced criminal law. That should be the main criteria. You need someone that has been in the court, be it a prosecutor or a defense attorney, who actually knows that, okay, they've been there 10 years, they've done trials. You don't appoint someone who has never been in the court. You actually have an open process where the public can see whose actually application is out. And the part about how you will deal with the voting is dealt with en banc. And at this point, since I'm not there yet, I don't want to say I'm going to do this and I need to know all the other criteria. But one thing, making it transparent, open it up where everybody knows who's actually applying for it, what are their qualifications, and I actually, one additional thing can have something like this, where a forum where all of the candidates come and they actually be interviewed.
Any question?
You know, it's strange that the practice of selecting the commissioners is a bit of a mystery to a lot of people because, as Mr. Moore said, it is done en banc, and it's not really highly publicized. Usually, you know, I've seen at certain times when the positions were open to be filled, that there would be flyers posted around the courthouse giving you a deadline to submit your resume if you were interested in the position. I can tell you, I just learned last week that the commissioner's positions that were actually supposed to be up this week had already been filled. I've never even seen it was publicized for people to submit resumes. You know, one of the things I'll tell you from the people I'm familiar with in court, they tell you that the commissioner positions are actually is more political than running for judge. Because most of the groups that are usually behind certain judges have certain candidates or certain people that they want to have those positions. I think if you want to restore integrity into that process, is that rather than just have the judges decide who the commissioners want to be, is that you provide a panel, and you maybe select panel from, you build a panel from a combination of the judges, defense attorneys, and prosecutors that are regulars and work in that building, and allow them to participate in some sort of forum and provide recommendations or votes on who those commissioners are going to be. Because let me tell you one thing, ladies and gentlemen, those commissioner positions are very important. That is your first line of defense when a person is accused. those are the people that set the bonds. Everybody wants to talk about how the judges are holding people on high bonds, but the commissioners are the ones that set those bonds. The commissioners are the ones that are conducting preliminary examinations and determining not whether the person is going to be held. So when y'all are unhappy with that circumstance and y'all point the finger at the judge, remember that that the person who actually set that bond had that preliminary hearing with the commission.
For those of you who may not know what we're talking about, inside baseball, a commissioner is sort of like a deputy judge. And that person is appointed by the judges in our parish, and their job primarily is to determine whether there's probable cause to hold somebody. The Constitution requires that that decision be made within 48 hours of a person's arrest if they were arrested without a warrant, an arrest warrant. Their second, lesser function, but an important function, is to set bail, an amount for bail, or to decide that the person can be released without coming up with financial bail. But they're at a critical junction, but the matter goes to the district judge ultimately, and what that commissioner does is always subject to review and change by the district judge. I don't have a particular feeling one way or the other about how they're appointed. Because I don't think in the overall picture it makes a whole lot of difference if the judge, the district judge, is doing the work that he or she is supposed to be doing. My intention is that every person who's going to get allotted to my section of court is going to get an independent review immediately of their conditions of bail when they come before me. So, and I think that's the way every judge should handle it. Thank you.
Okay, we're winding down this first half of the forum, so just a couple more questions, but I think this next question is very important on the minds of a lot of people here, which is all of the studies, focus, attention, and both in media accounts of Louisiana's high incarceration rate. New Orleans is no exception. Is there anything that you could or would do as judge to address high incarceration rates?
Yeah, I plan to address it. That's the reason I'm running, really, is to address that very problem. The first thing is the initial incarceration, pretrial detention. That needs to be looked at so carefully, but we need to have systems put into place where people can be released into some sort of secure, supervised program when they're released pre-trial. The chances of them succeeding, not being incarcerated pre-trial, helps their chances of them being reintegrated into our community, into our city, in the long run. Secondly, we have used our criminal justice system, Mike, for dumping all our social problems. So the lack of education, the lack of employment, mental illness, drug addiction are all being dumped onto this system that cannot support it. And we as judges need to begin to weed our way through those problems and create programs that people can be taken out of the justice system sooner rather than later. So for example, I would be a person that would tell somebody, look, I'm going to release you. You go do this, this, and this, sort of like a pre-probation. And at the end of it, if you succeed, I'm going to sentence you, and I'm going to let you go at that point. You follow? Because we don't need, we are revoking, our prison population consists of 50% of people whose probation was revoked. This is an indictment of us. And it's also, we have the highest number of non-violent drug offenders in our penitentiary than anywhere in the United States of America and the world.
First of all, if we're going to address the, should I say, the pre-conviction or incarceration while cases are pending, first thing we need to make sure we're setting adequate bonds. If we don't need to make sure we're not detaining people that don't need to be detained. We need to work with groups such as the Bureau Institute that make recommendations to the judges of a person's dangerousness to themselves and to others and whether or not they're going to be released. We need to use the resources that are available that are sometimes being ignored to determine whether or not a person can be released on their own recognizance or into one of these programs that Judge Bowman is talking about. If we're talking about post-conviction incarceration, let me just tell you this. If I'm going to sit here and tell you that, hey, we got too many people in jail, I'm going to have to start finding everybody not guilty, I'm not doing my job. As a judge, you have to follow the law. You have to hold the state accountable. If they prove a case beyond a reasonable doubt, a person is convicted. But unfortunately, the law, the legislature has sentences that are mandatory in most cases. So, to be honest with you, we can all talk about what we would do as far as this, that, and other, but most judges, criminal court judges have had their discretion taken away from them because of the legislature and the laws that are currently in place. Not just the mandatory minimum, but also the legislature allowing of the district attorneys in all parishes. I know everybody's going to keep talking about Orleans because it's where we're at, and they also take a sideways shot at me because I'm a prosecutor, but let me just say this, the multiple bill. The current legislature allows a multiple bill to be filed. And when the district attorney uses the multiple bill, it takes away the discretion of the judges, and it provides an additional mandatory minimum. So, and the best way we can try to prevent or to work on incarceration rate is to stop people from coming through the system. And that is by expanding the services that I talked about in the beginning, providing drug rehabilitation, providing services such as mental health services, but one additional step, working with the community, working with the businesses and the groups out there to help people get employment. Doesn't matter if we can get you off your drugs, if we can get you mental health treatment, if we can teach you a trade, if you can't go out and work. If you can't get a job, you're going to end up doing whatever it was that got you in the system in the first place, and that is going to continue to contribute to our crime problem. What I'm determined to do is stand with the community, work with the businesses, and work with anybody that's willing to give my brothers and sisters a chance. That's what I'm willing to do, and I'm going to ask y'all to stand with me and do that.
It's really simple. Judges do have policy or powers that when they actually sentence people for nonviolent crimes, there are alternatives to putting a person in jail. They do have it where they can actually have home incarceration, but no one ever talks about that. That's one thing that we can do right now before we as judges and get our brother and sister on the bar to go forward to the state to say we need to get rid of this idiotic system that we think that we're going to incarcerate ourselves out of the situation we're in. The judges now have powers to actually have pre-trial releases as it stands. We can actually do, when a person comes in, I think Judge Cronin and I think Mr. Gilbert has already said, they'll look at the bonds, but you also can look and say, have a low bond. A person is still innocent until proven guilty. And stop trying to put it off on everybody else. It's easy to say it's the commissioner's fault. No, it's the judge's fault. It's our fault. When we don't take the time to go through and say, reduce the bond. Bond is supposed to make sure that a person comes to trial, comes to court. We do look at the dangerousness, but nobody look at the danger. They don't look at that. They just say, put them in jail and keep them in jail. So we look at the policy by which the judges use in the law that we currently have until we can go to the legislature and make them change, where we can actually reduce people from being in jail, incarcerated, until that case goes through. It makes no sense that a case now, a simple marijuana case, let's say a cocaine case, can take up to a year to finish. And if you have a person that's incarcerated and because they don't have money to get out, the judges can actually use their power and their discretion to say, we'll let them out. Either we put them on home incarceration or put them on a monitoring system. That's what needs to be done. And then we need to stop talking and go down to the legislature and say, let's get rid of the multiple bill. Because 75% of the multiple bills came out of 3 parishes: Orleans, St. Tammany, and Jefferson. Those are 3 places where it came out.
Okay, we have one last question before we get to some closing remarks and then on to the next forum. This question is multiple parts. Handle it however you wish. It involves the efficiency of the court. I think anyone who's spent some time at Tulane and Broad would not accuse that building of being the model of efficiency, whether it's attorneys waiting, police officers waiting, multiple trials scheduled on a single day, when clearly maybe one or even none of those is actually going to take place. And on the flip side of that, many courtrooms are vacated by lunchtime. Clearly inefficient. Is there anything that can be done? And I will also pose this. Many neutral studies of the court have recommended reducing the number of judgeships. That there's simply not the caseload in New Orleans, especially post Katrina, to support 12 sitting judges and a magistrate judge. What would you do to address efficiency and possibly even downsizing the court?
Dealing with the efficiency of the court, and I started first, we need to use technology, and then also go out and look at what other courts are using in the state of Louisiana to figure out how we can be more efficient. I.e., you can say on Monday of a week, you have a trial week. You have all the trials that are set to be possibly on docket to go that week, they come in on Monday. And you make a decision, determination then on what cases actually will be going on that day. So then you don't have everybody coming back on Tuesday, Wednesday, Thursday, Friday when they know that they're not going to be there. Another issue that you can use, you can actually set up certain days that you're going to have motion hearings. You're going to have certain days that you have arraignments. It's a lot of things that you need to do. Also, you need to take the control from the district attorney's office in setting the docket and let the court set its docket. That way the court knows what's going on at that time. Now, as it relates to reducing the judgeship, I don't believe that is right now. I believe that if we go through and say, well, all we have to do is just cut judges, and then we'll be okay. We'll find ourselves 5, 10, 15 years down the line, and we have a docket that's actually triple the size it is now. Before we go and start saying, let's cut something, let's do the efficiency to see what we can do in the court system using technology, using different systems, look at different courts, what they have done to make sure that their courts are more efficient, and implement those first. And then maybe down the line, and I look at it at this point, in 6 years, in 2020 is the next time that they possibly can look at reduction of court seats. 2020 or 2026, we come back and we actually look at it at that time. Right now, I don't think that it's the time to reduce the size of the court. I think we need to use other methods to actually deal with efficiency.
I'll start with the second half of the question first. I do not agree that the court should be downsized right now. I can tell you, not only am I a homicide prosecutor, I'm also a supervisor to three sections of court. And I can tell you that the average caseload in court for the judges is roughly between 200 and 300, with numerous arraignments coming a day, not to mention indictments. And with the current allotment system, where cases are allotted by the date of offense, which means that any crime that happens on Monday will go to one judge, anything that happens on Tuesday will go to another judge. Sometimes a case that comes through can be very voluminous. And so downsizing the court will only serve to delay the cases that are currently pending. Now, if we're going to try to be more efficient, I think one of the things that needs to occur is, I do agree there does need to be an increase in technology. We need to improve the technology in the courthouse. One of the things that would be a great asset, I believe, would be a centralized court calendar. So when dates are being selected, the judges they can have some sort of computer system that lets the judges know which attorneys are already scheduled to have things in other trials. Let me tell you, you have a lot of very popular attorneys. I see several of them in this building, and they practice in all sections of court and some in other parishes. And if you set a trial date on November 11th, and the judge has you scheduled for trial November 11th in 3 other sections, but you can only be in one place at one time, so you can only try one case, which means as a result, 3 cases are going to be continued, and if you're in another parish, everything is being continued. So I think if there was a system that would allow the judges and the attorneys to be on the same page when selecting dates, we can eliminate some of those conflicts.
Yeah, I'll take the second question about reduction of judges. I was on all the committees appointed by the Supreme Court to study the issue of reduction of judges across the line. There are places where we could probably marginally reduce some judges, and I'm fine with that, and I've testified before the legislature on how I thought it could best be done. Because I was not oppositional to the Bureau of Governmental Research when they were suggesting it, as many judges were. That's number one. Number two, but when you really looked at it and brought in national experts who know how to look at case management and case volume, everybody said, are y'all crazy about reducing the number of judges at criminal district court? The volume was too much. But again, the real question here, so I'm not for that right now. I don't see the point. Because there's too many people sitting in jail and not enough judges dealing with the problem. Now, on efficiency, here is what the Constitution says. The Constitution doesn't say be efficient. The Constitution says due process of law. And that everyone is entitled to the due process of law. Now, that doesn't mean either that a judge should be gratuitously inefficient. That was craziness. I'll sit on a court, we have timelines, we try to adhere to it, we try to do our work in a timely fashion. The public expects it and the public's entitled to it. But setting arbitrary standards for efficiency, no. The Constitution says due process, and that's my pledge to you. That's what I pledge, is to adhere to that rule.
Okay, very good.